Donald Trump, the former president of the United States, has often found himself at the center of controversy, legal battles, and heated political discourse. However, the ongoing legal cases related to his actions surrounding the January 6th Capitol riot may present the most significant threat to his political career and personal freedom. In particular, his recent legal filing, which was intended to shield him from prosecution, may have inadvertently admitted something far more damaging: that his actions on January 6th were in a personal capacity, not as the President of the United States. This revelation has opened the door for Special Counsel Jack Smith to capitalize on a legal trap that could fundamentally shift the trajectory of Trump's legal defense. The case, which revolves around Trump's alleged interference in the 2020 presidential election and the Capitol insurrection, has already seen its fair share of delays and legal maneuvering. Still, the latest developments suggest that Trump's own words may be the key to unraveling his defense. Let's dive into how Trump's legal team may have walked right into a trap and how this could seal his fate. The broad immunity ruling, Trump's misstep. In the lead-up to the January 6th riot, Trump's actions were under intense scrutiny, with accusations that he attempted to leverage his position as president to overturn the results of the 2020 election. His legal team has consistently argued that his actions were part of his official duties, thereby protecting him under the doctrine of presidential immunity. This concept holds that a sitting president cannot be held criminally liable for actions taken as part of their official role. The Supreme Court's recent ruling, which provided a broad interpretation of presidential immunity, initially seemed like a victory for Trump. The ruling, handed down by a 6-3 majority of conservative justices, appeared to give Trump cover, allowing him to argue that his involvement in the January 6th events was part of his presidential duties, thereby protecting him from legal consequences. Trump even celebrated the ruling, confident that it would shield him from prosecution. However, as the old adage goes, be careful what you wish for. The very immunity that Trump sought to hide behind has now created an opportunity for Jack Smith and his team of prosecutors to reveal the full extent of Trump's involvement in the events surrounding January 6th. The legal argument that Trump's actions were official conduct is about to be dismantled, thanks to a line in Trump's own legal filing that may have irreversibly undermined his defense. Trump's fatal filing, a legal admission? In a recent filing opposing the release of information related to Jack Smith's investigation, Trump's legal team may have made a critical error. In their argument, they claimed that Trump's speech on January 6th was protected under the First Amendment. The filing stated, "Bedrock First Amendment principles permit public speakers, including President Trump, on January 6th to speak their mind without fear of criminal prosecution for the unlawful acts of others." At first glance, this may seem like a simple assertion of Trump's right to free speech, a fundamental protection guaranteed to every American citizen. But the problem lies in what this statement implies: that Trump was speaking in a personal capacity, not as president. The First Amendment protects citizens from government interference in their speech, not government officials acting in their official capacity. By invoking the First Amendment, Trump's legal team has essentially admitted that Trump's actions on January 6th were not official presidential duties, but rather the actions of a private citizen. This is precisely the trap that Jack Smith had set, and Trump's team walked right into it. The First Amendment and presidential immunity. To understand why this is such a significant misstep, we need to examine the relationship between the First Amendment and presidential immunity. The First Amendment protects individuals from government encroachment on their speech. This means that when a citizen speaks out, they are protected from government retaliation or prosecution based on their speech. However, government officials, including the president, do not enjoy First Amendment protection in the same way when they are acting in their official capacity. Instead, their actions are governed by different legal standards. For months, Trump's legal team has tried to argue that his actions on January 6th were part of his official role as president. This would, in theory, grant him immunity from prosecution under the Supreme Court's broad ruling. But by invoking the First Amendment in their recent filing, they have effectively conceded that Trump was not acting as president on that day, but as a private citizen. Jack Smith, the special counsel overseeing the investigation, was quick to seize on this. In his response to the Supreme Court's ruling, Smith pointed out the contradiction in Trump's argument. He highlighted that the First Amendment protects private citizens, not government officials, and therefore, by seeking First Amendment protection, Trump was admitting that his actions were not official conduct. Smith's brief stated, "The First Amendment constrains governmental actors and protects private actors." Petitioner Trump confirmed that he acted in a private capacity by seeking First Amendment protection for his false speech. Petitioner's assertion of private First Amendment rights speaks volumes about the private character of the charged offenses. In other words, Trump's reliance on the First Amendment to defend his actions on January 6th has provided the prosecution with the evidence they needed to argue that Trump was acting outside of his presidential duties, making him vulnerable to criminal charges. The implications for Trump's legal defense. This misstep could prove disastrous for Trump's defense in the January 6th case. Up until now, Trump's legal team has relied heavily on the argument that his actions were protected by presidential immunity. They argued that everything he did in the lead-up to and during the January 6th insurrection was part of his role as president, which would shield him from prosecution. But now, with this new admission, Trump has undercut his own defense. If the court accepts that Trump was acting in a personal capacity, he would no longer be able to claim immunity, and he could be held personally responsible for his actions. Jack Smith's team is likely to use this filing as a key piece of evidence in their case against Trump. By admitting that Trump was speaking as a private citizen, they can argue that his actions were not protected by the broad immunity granted to sitting presidents. This could open the door to criminal charges related to his involvement in the Capitol riot and his efforts to overturn the 2020 election results. Judge Chutkan's role. A critical decision ahead. Judge Tanya Chutkan, who is presiding over the Washington, D.C. election interference case, will play a pivotal role in determining the outcome of this legal battle. Chutkan has already demonstrated a no-nonsense approach in handling Trump's legal team, and she has not been swayed by the former president's attempts to delay or derail the proceedings. Now, with Trump's own filing admitting that his actions were personal and not official, Judge Chutkan is likely to take a hard look at the arguments for and against Trump's immunity. If she agrees with Jack Smith's interpretation of Trump's First Amendment defense, it could significantly weaken Trump's position and pave the way for a full trial. Chutkan's decision could have far-reaching implications, not just for Trump, but for the future of presidential immunity and accountability. If she rules that Trump's actions on January 6th were not covered by immunity, it would send a clear message that even former presidents are not above the law. The broader impact. What this means for the 2024 election. The timing of these legal developments could not be more critical. As Trump prepares for a potential 2024 presidential run, the outcome of this case could have a profound impact on his campaign. Trump has already positioned himself as a martyr in the eyes of his supporters, claiming that the legal cases against him are part of a witch hunt designed to prevent him from running for office again. However, if Trump is found guilty of criminal conduct related to January 6th, it would severely undermine his chances of reclaiming the presidency. Not only would it damage his public image, but it could also lead to legal consequences that would prevent him from running for office. Moreover, the January 6th case is just one of several legal battles that Trump is facing. From the Stormy Daniels hush money case in New York to the classified documents case in Florida, Trump is embroiled in a web of legal challenges that could threaten his political future. Donald Trump's legal defense in the January 6th case has taken a significant hit, thanks to a seemingly small but critical error in his legal filing. By invoking the First Amendment to defend his actions, Trump has inadvertently admitted that he was acting in a personal capacity, not as president. This admission could prove to be the turning point in the case, allowing Special Counsel Jack Smith to argue that Trump's actions are not protected by presidential immunity. As the case moves forward, all eyes will be on Judge Tanya Chutkan and her decision regarding Trump's immunity claim. If the court rules that Trump was acting as a private citizen on January 6th, it could open the door to criminal charges and potentially derail Trump's political ambitions. In the end, this legal battle is not just about Trump's actions on January 6th. It's about the broader question of accountability for those in power. If Trump is held accountable for his role in the Capitol riot, it will send a powerful message that no one, not even a former president, is above the law.